Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers video evidence, tampering, and witness identifications, and is brought to us by Vigilant Cam's channel. Be sure to check out the description below and give them the credit that they deserve. On June 3rd, 2022, Police Chief Anthony Alvarez of the Elmira Police Department was wearing plain clothes and driving in an unmarked vehicle in Elmira, New York, when he noticed that 30-year-old Isaiah Bowman Thomas and another individual were involved in an argument that he believed might become physical. Chief Alvarez pulled alongside the two individuals and asked Mr. Bowman Thomas if everything was okay. And Mr. Bowman Thomas allegedly challenged Chief Alvarez to a fight. Chief Alvarez then exited his vehicle, and Mr. Bowman Thomas allegedly continued to make aggressive movements toward Chief Alvarez. Chief Alvarez then noticed that Mr. Bowman Thomas was holding an open knife in hand and ordered him at gunpoint to drop the knife. Mr. Bowman Thomas eventually dropped the knife, and Chief Alvarez ordered him to the ground. Chief Alvarez was not wearing a body camera at the time of the incident, so the initial altercation with Mr. Bowman Thomas was not captured on body camera. However, backup officers arrived on the scene to assist with Mr. Bowman Thomas's arrest, and the interactions that followed were recorded on their body cameras.
You want to treat the black people like this. Watch this.
All right, we're rolling on your side.
Watch how you guys
Hey,
let
you
me.
got a couple more knives.
Yeah, I got one more knife.
Where is it?
I just showed you right here.
All right.
In my pocket. You don't feel that? It's all on camera. I will have your job. Now what are y'all doing?
Just slide in.
I don't have no warrants. So what am I being
Slide
detained
in.
for? What am I being detained for?
Threatened me with a knife. I don't know what else more to tell you. He was fighting with a guy on the other side of the street, challenged each other. I just pulled up and said, "You guys done?" He asked me if I wanted to fight. I said, "I want you to move along." I come around. Come on.
What am I being arrested for?
Well, that will be discussed shortly.
You said you saw the whole thing? When he came at me with a knife? When did you start recording?
When you pulled your gun
When
on
I pulled
him?
my gun out on him?
Yep.
Good, because they still have the knife in his hand, so I'm going to need their information.
I didn't record
Can we
nothing.
check
up
that,
until-
please? Make
No.
sure you don't record this evidential effects, because I don't have a camera on my car and I don't have a body cam,
Well, you should.
but it's evidence. So if you
No.
caught him with a knife in his hand,
I did not.
that would help me with my
I did
criminal
not.
case.
I just said I did not.
Can we check?
Then what's the point of this?
No.
Then why are you
If you
filming?
didn't have it? If the whole point is
What
to
if-
get evidence for a
what-
criminal matter.
What if I was doing it for the benefit of you and now y'all are coming at me with
I am.
evidence?
I know. Can I have the video for the benefit
No,
of
you
it?
cannot because it's.
So
this
you're
is-
not doing it for the benefit
This
of the
is not my phone.
It doesn't matter.
You're in
in
possession
control
of
It
it.
does.
No, it doesn't.
That's
man.
not my car, but I'm in control of it. It's the city of Elmira's car.
Good. Can I have it?
No.
There's no reason for you
Good
to have
point.
it.
Touche.
Chief Alvarez asks the witness if he can check the video on her phone to see what part of the altercation with Mr. Bowman Thomas she had recorded, and she refused. As we have discussed many times here on ATA, citizens are generally not obligated to assist officers with their investigations, and absent extenuating or so-called exigent circumstances, officers typically cannot seize evidence or even view data or video footage on an individual's cell phone without consent. However, officers and prosecutors may use procedural tools, such as warrants and subpoenas, to secure testimony and obtain evidence from witnesses. According to Section 690.05 of the New York Criminal Procedure Law, a local criminal court may issue a search warrant upon application of a police officer, a district attorney, or another public servant acting in the course of their official duties. The statute also states that, now quoting, "A search warrant is a court order and process directing a police officer to conduct a search of designated premises or of a designated vehicle or of a designated person for the purpose of seizing designated property or kinds of property, and to deliver any property so obtained to the court which issued the warrant." Additionally, Section 690.10 of the Criminal Procedure Law states that, quote, "Personal property is subject to seizure pursuant to a search warrant if there is reasonable cause to believe that it constitutes evidence or tends to demonstrate that an offense was committed in this state or another state." Likewise, under Section 610.10 of the New York Criminal Procedure Law, quote, "A person at liberty within the state may be required to attend a criminal court action or proceeding as a witness by the issuance and service upon him of a subpoena." As this statute explains, now quoting again, "A subpoena is a process of a court directing the person to whom it is addressed to attend and appear as a witness in a designated action or proceeding in such court." The statute also notes that the term subpoena includes a so-called subpoena duces tecum, which is, now quoting again, "a subpoena requiring the witness to bring with him and produce specified physical evidence." According to Section 610.25 of the Criminal Procedure Law, quote, "Where a subpoena duces tecum is issued on reasonable notice to the person subpoenaed subpoenaed, the court or grand jury shall have the right to possession of the subpoenaed evidence. Further, in situations where witnesses are particularly uncooperative, a so-called material witness order may be obtained. As Section 620.10 of the Criminal Procedure Law explains, quote, a material witness order is a court order adjudging a person a material witness in a pending criminal action and fixing bail to secure his future attendance thereat. Under Section 620.20 of the Criminal Procedure Law, quote, a material witness order may be issued upon the ground that there is reasonable cause to believe that a person whom the people or the defendant desire to call as a witness in a pending criminal action possesses information material to the determination of such action and will not be amenable or responsive to a subpoena at the time when his attendance will be sought. Therefore, although a court would almost certainly conclude that the witness was not obligated to allow Chief Alvarez to view the video recording she captured on her cell phone at the scene, it could likely be obtained with a search warrant or a subpoena, and her appearance in court could be required through a subpoena or a material witness order.
Anyway, so we're going to get your name because you're witnesses to this. I have
That's
to for my
all right.
UPR.
No, you don't.
I mean, my,
No, you do not.
not UPR, my use
No,
of
you
force
do not.
report. Yes, I do.
So you're just out here just to be jerks and
Can you
harass
please
us,
get
right?
the names?
Yeah, like seriously. Like, this is ridiculous. We didn't do anything wrong or illegal, yet you guys are not even remotely
Yo, neither
cooperating
did
with us.
I.
But
State.
I did not do anything.
no, but you're not cooperating in a criminal investigation. That's ridiculous. It'd be one thing if you just walked by.
All
and you-
I did
But you're
was
blatantly
see-
here.
All I did was see something
What did you
that
see?
happened.
Oh, something. So then what's the
I
point
see-
of, so just nothing. You just saw nothing.
Yo, yeah, get out of here.
Miss?
This is this
Hey,
is
stop.
whoa.
Stop. Don't approach her
Get
that
out of
way.
my car.
We're not in your car. Back off or you're going to jail. We're not getting in your car.
You're not going to tell me to get away from my car.
Please back away from us.
Right. There's no reason to approach
Please
the chief
back away
like
from
that.
my
I have every
car.
right to look at cars. It's called VNT.
Okay, I'm going to go look at your car
I
then,
need
all
to-
right?
You're not identifying yourself, so I'm going to use your vehicle.
You're not
as a-
identifying
as a
yourself
potential-
either. Neither one of you have identified.
Alvarez, 4588.
Okay, cool.
So I am going to identify you. You are a potential witness
Okay.
in a criminal matter, and
Okay.
now apparently you want to say that the police are abusing their power.
Whoa. Get out of here, man.
We don't need that.
You don't want
You
that
don't-
bad?
I
It's
just need
not
her
this.
name.
It's not.
You are going to give us, if this is your vehicle.
I have no problem giving you my name. That's not what
then
you all
do so.
started. That's not what
If
you
you don't
even
want to
started.
give us the video, we will subpoena it if we need to later. That
Go
is fine.
ahead.
And if you destroy it, it's evidence and it's a felony. So you cannot delete the video. Is that being
It's
recorded?
not. It's
Yes.
not. It's not.
If you delete the video, you are destroying evidence, which is a felony in New York State.
Chief Alvarez warns the witness not to delete video from her cell phone, claiming that it would be a felony offense for her to do so. Under Section 215.40 of the New York Penal Law, a person is guilty of tampering with physical evidence, which is a Class E felony, quote, when, believing that certain physical evidence is about to be produced or used in an official proceeding or a prospective official proceeding, and intending to prevent such production or use, he suppresses it by any act of concealment, alteration, or destruction, or by employing force, intimidation, or deception against any person. Section 215.35 of the Penal Law further explains that, now quoting again, physical evidence means any article, object, document, record, or other thing of physical substance which is or is about to be produced or used as evidence in an official proceeding. And, now quoting again, official proceeding means any action or proceeding conducted by or before a legally constituted judicial, legislative, administrative, or other governmental agency or official in which evidence may properly be received. In the 1979 case of People versus Nicholas, the Appellate Division of the Supreme Court of New York determined that for an act to be considered tampering with physical evidence, it is not necessary for an official proceeding to have been initiated at the time of the act of concealment, alteration, or destruction. Rather, as the Criminal Court of the City of New York explained in the 1989 case of People versus Simon, quote, it is clear that the phrase official proceeding is not restricted to those proceedings which are actually pending at the moment that the evidence is allegedly tampered with, since the crime refers to both an existing or a prospective official proceeding. However, an essential element of the crime of tampering with physical evidence is that the defendant believed that the physical evidence is about to be produced or used in an official or prospective official proceeding, and that the defendant intended to prevent such production or use. Accordingly, if the witness deleted the video of the altercation between Chief Alvarez and Mr. Bowman Thomas from the phone with the intent to prevent it from being used in Mr. Bowman Thomas's prosecution, it is possible that she could be convicted of the felony level crime of tampering with physical evidence.
Okay.
You filmed me taking my gun out.
No,
and
I did
pointing it
not.
at him.
I did not
You've already
film
admitted it.
that.
You said you did.
I
You've already
said I
admitted it.
seen it with my eyes.
Well,
I
just put
didn't record it.
And don't wave your
I
fist
didn't-
at me again.
I didn't.
You wave your fist at me again, I'm going to arrest you.
I didn't wave my fist at you.
Well,
Watch
that's
freaking. Yeah, I said this.
That's two.
Oh my God, get a grip,
Give
bro.
me your driver's license and your registration
No,
because
I
you
am
drove this
not.
car.
No, I.
You ain't. You're giving it to me because
Whoa,
you have to.
Whoa.
You don't have a
Whoa.
choice but to identify
What did
yourself.
I?
You have to
do?
identify yourself.
What did I do?
You drove a car. Let me see your driver's license
What
to
did-
make
what-
sure that
what-
you are a registered driver.
Okay.
You inserted yourself into the situation, man.
No.
We
no.
did nothing to you.
No.
That's fine.
We had nothing to do with you until you inserted yourself and started filming. So now, guess what?
Listen,
inserted
you need to
yourself
lose
into
the
a
attitude because I was going to start being cooperative with you until you tell me to give me my
license,
give me
registration,
my-
insurance card, please.
No.
Yes.
Get out of your mind. I will
Then you will
gladly.
be under arrest for
Listen,
obstruction.
I will gladly give you my license. I have to get in the car
Okay.
to get it.
Then
Where
go
is
ahead
it?
and do that, please.
In
I'm
my-
not retrieving it, but just
It's in my bag.
that black one right there.
No, the one back there.
Chief Alvarez claims that the witness must show her driver's license because she drove a vehicle, and that if she refuses to do so, she will be arrested for obstruction. Under Section 507 of the New York Vehicle and Traffic Law, quote, failure by a licensee to exhibit a license to any police officer shall be presumptive evidence that he is not duly licensed. Now, while some states make refusing to show a driver's license an independent crime or violation, as the U.S. District Court for the Eastern District of New York explained in the 2019 case of Morrison versus City of New York, quote, under New York law, it is not a crime or traffic violation to fail to produce a license upon demand. Further, even if New York law criminalized an individual's refusal to display their driver's license during a traffic stop, it is well established that an officer must have at least reasonable suspicion to demand to see a driver's license under such statutes. For instance, the Supreme Court concluded in the 1979 case of Delaware versus Prowse that stopping an automobile and detaining the driver in order to check his driver's license without at least reasonable suspicion of a legal infraction is a violation of the Fourth Amendment. Likewise, under Section 140.50 of the New York Criminal Procedure Law, quote, a police officer may stop a person in a public place when he reasonably suspects that such person is committing, has committed, or is about to commit either a felony or a misdemeanor, and may demand of him his name, address, and an explanation of his conduct. However, not only does this statute require reasonable suspicion, it also does not authorize police officers to require driver's licenses or to arrest individuals who refuse to identify themselves. Now, as to whether the witness could be charged with obstruction, Section 195.05 of the New York Penal Law states that, quote, a person is guilty of obstructing governmental administration when he intentionally obstructs, impairs, or perverts the administration of law or other governmental function, or prevents or attempts to prevent a public servant from performing an official function by means of intimidation, physical force, or interference, or by means of any independently unlawful act. Courts applying this statute have consistently found that an individual's refusal to identify themselves does not constitute obstructing, even when an officer has the reasonable suspicion necessary to detain them. As the U.S. District Court for the Southern District of New York explained in the 2006 case of Williams versus the City of Mount Vernon, quote, although there is no Fourth Amendment right to refuse identification, any obligation to identify oneself stems from applicable state law. The court then reviewed several New York cases that determined that, now quoting, ignoring an officer's request for identification is not a crime, and that, now quoting again, the failure to stop or cooperate by identifying oneself or answering questions cannot be the predicate for an arrest absent other circumstances constituting probable cause. Similarly, in the 2005 case of People versus Grouillon, the criminal court of the City of New York held that a witness did not commit obstruction by refusing to cooperate with the police, noting that, now quoting, while the police were authorized to investigate and to question witnesses, the police did not have the authority to force the defendant to remain in that location to answer questions, and that police officers may use methods such as subpoenas and material witness orders to secure a witness's presence at criminal proceedings. Now, it should be mentioned that the witness in the Grouillon case had provided the officers with her contact information before refusing further cooperation, but given the requirement of physical force or interference, or an independently unlawful act to sustain an obstruction conviction, it still seems highly unlikely that the witness could be found guilty of obstruction for refusing to show her driver's license to Chief Alvarez.
Oh, Jesus. You know that's a gift.
This?
That's a gift for my boyfriend.
We'll give it back. It's just we're holding it for safety right now.
That's fine with me. Okay, I can't get it.
She should not be reaching into the car.
She gave her permission to.
We ain't doing nothing like y'all are thinking, so just
For some reason, you want
cooperating at the moment, right?
Yeah.
Sure.
The sooner we get your ID, the sooner we leave.
I'm working on
Okay.
it. I just got my bag up here. There you are, sir, ma'am, sirs. Sorry,
Okay.
that's a joke that I do have. Bad joke timing.
Where are you living these days? Still.
Right there.
Since you guys were so interested in this, I'll give you a rundown of what was going on.
You didn't talk to Comm Center about this?
Not her yet.
Additional subject for the chief's blotter.
So, That is it. That's the extent of this. And I'm just curious why you wouldn't want to share that video to prove my case against somebody that was trying to get in fights with
It wasn't that I
Just
didn't want
add
to share it. It was that you wanted to take my phone.
You said you didn't have a certain part. I wanted
Right, I
to
didn't
watch
have-
the video to see what you had. But you didn't see him pacing back and forth and challenging me.
I saw it.
But not recorded.
No, excuse me. I did not see that part of it. I commend y'all for the jobs that you do. But you also have to understand that there are grimy ones with y'all too.
Right,
I
but
was
if
starting to be-
we were one of those grimy ones,
Which,
even though yes, we were talking, going back and forth with you, but what would stop us from just like blatantly doing something savage to get that far? We wouldn't. If the
Oh,
chief
not in
was
that
one of those
way.
grimy ones, as you said, I'm using your term. If he was one of those grimy ones, just pointing guns at people, just out hurting people, I highly doubt he would just let you sit there and record. You know what I mean?
you don't know that though.
Well, I guess what I'm saying is police that are out committing violent felonies, the showing of a camera wouldn't stop it. It wouldn't stop a civilian like that.
Right, but I'm not. You're going from one extreme to the other. There's those ones that are in between as well that are gonna push as far as they can absolutely push and possibly
I see.
push somebody over. You know what I mean?
I see.
And that's one extreme to the other. You know,
So,
I mean.
Are we good? Are you
Yeah,
done?
we're
Okay.
done.
All right. Of course.
Sorry about that. I forgot I had that there.
You can keep it in there. Just you got to understand, we're going to just address as a potential threat. It doesn't make it illegal.
No,
we just
yeah.
take it out of the situation.
Yep.
Give it back to you just like I did. Yep. Good.
Mr. Bowman Thomas was charged with second-degree menacing and disorderly conduct and released on an appearance ticket after processing. The final outcome of these charges has not been made publicly available. It is unknown whether the witness filed a complaint or pursued any sort of legal action after this encounter. In January of 2023, Chief Alvarez was terminated from his position at the Elmira Police Department due to his conduct during an investigation into a December 9th, 2022 arrest where he drove an unmarked vehicle into a home's front lawn, pulled out his firearm, and threatened to shoot a fleeing suspect in the face. Although Chief Alvarez was not terminated for his actions during this arrest, City Manager Mike Collins told Chief Alvarez at the meeting where he was terminated that, and I'm quoting, "I have completed my investigation and I have determined that your conduct regarding the incident, together with your behavior this past week, constitutes unprofessionalism and insubordination." City Manager Collins then told Chief Alvarez that he could choose to resign or be terminated, and Chief Alvarez chose termination. Overall, Chief Alvarez and the Elmira officer who assisted him get a C- for maintaining an aggressive and hostile demeanor throughout the encounter, threatening to arrest a witness when they would not have had probable cause to do so, and demonstrating a fundamental misunderstanding of when police officers can demand to see a driver's license under New York law. Now, while I appreciate that the officers ultimately did not illegally seize the cell phone and demonstrated an appropriate level of respect for the protections the Fourth Amendment grants to personal property, on the whole, the encounter was unprofessional and likely infringed on the witness's Fourth Amendment right to be free from unreasonable seizures. I can understand why the officers were passionate about securing evidence that could be used against Mr. Bowman Thomas, but they needed to respect the fact that citizens are not required to assist them with their investigations, and accordingly should have taken a less abrasive tone with the witness instead of repeatedly threatening her with arrest to secure compliance. The witness gets a B, because while she was slightly physically and verbally aggressive with the officers at times, she largely maintained a firm but respectful demeanor and attempted to defend her constitutional rights at multiple points during the encounter. For instance, the witness successfully asserted her right not to show the cell phone video footage to the officers, and while it would not have been any sort of failure if she had chosen to share what she had recorded, she was well within her rights to choose not to. Additionally, although she was likely not legally obligated to provide the officers with her driver's license, there's nothing inherently wrong with a witness choosing to cooperate with the police, and given the fact that she was threatened with arrest, I cannot fault her for choosing to comply with the order. Based on her conversations with the officers, it seems likely that the witness chose to record the original altercation for Mr. Bowman Thomas's protection, and not to obtain evidence that the police could use against him. And although the officers were likely legally entitled to obtain the footage through the appropriate legal procedures, this encounter demonstrates the importance of officer demeanor in securing consent and cooperation from witnesses. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.